Good morning, everyone. My name is Eric Eisenman. I am a partner in Husch Blackwell's Milwaukee office, and I currently serve as the practice group leader for our national labor and employment practice. I hope everyone had a spooky and fun extended Halloween weekend. I have two daughters that are right in the Halloween sweet spot, ages 8 and 11. So I had a good time last night assessing the dad candy tax, collecting at least 10% of all candy, including all Almond Joy and 100 Grand bars that I could find in their Halloween pumpkins. Hope you had the same luck. But Halloween's behind us. The midterm elections are now in front of us. And this is an excellent time for a labor and employment legal update for Wisconsin and Illinois. Before we begin, I'd like to start with a couple housekeeping items. At the bottom of the audience console that you have today, there are a couple different application icons that will be useful for you. If you have questions during our presentation today, you can submit those via the question box. We have a team of crack labor and employment attorneys in our green room that are reviewing those, and we'll try to answer as many of those as we can today. If we don't get to them, we're going to try to follow up and provide you with an answer sometime after our presentation. A PDF of our presentation will be available in the resources folder. This program has been approved for CLE and continuing legal education hours. To report your hours, you click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast that you can watch and share. So you'll be able to forward this along to others in your organization. Towards the end of the presentation, we're going to ask you to complete a short survey. We really appreciate your feedback, as that helps us plan future seminars to make sure that we're touching on the topics that are most important to you. That's it for the housekeeping items. Let's move to get started with our program. We have 5 sections of content today. Each of them are going to be about 15 to 20 minutes in length. You should feel free to take a break during our program as needed, as there are no formal breaks scheduled into the program. I was mentioning to some of my colleagues earlier, those of you who attended our national seminar wanted to stick around for the breaks because we had our partner, AJ Weissler, who was quite the amateur comedian. I'm afraid there might be a few jokes here today, but we're not going to have a scheduled humor content like that. One of the things I'm most excited about today is the opportunity to introduce some new faces to you from our L&E team. We've had some terrific growth, both in Wisconsin and Illinois, and a number of those talented lawyers are going to be presenting today, including in our first group. To get us started, I am pleased to introduce Scott LeBlanc, Sam Mitchell, and Melissa Williams. Scott is a partner in our Milwaukee office, Sam, a senior associate here in Milwaukee, and Melissa, a senior counsel in Madison. They're going to share a legal update on Wisconsin's Arrest and Conviction Record Discrimination Statute, including the Wisconsin Supreme Court's recent decision in the Cree case. I know this topic has generated a lot of interest among our clients, particularly as many businesses are reassessing their background check process, particularly in a tight labor market. With that, I'm going to turn it over to Scott.
Thanks, Eric, and thanks everyone for joining us today. As Eric mentioned, my name is Scott LeBlanc. I'm a partner here in the Milwaukee office. I'm also licensed to practice in Illinois, and with me is Melissa Williams, senior counsel in our Madison office, and Sam Mitchell, senior associate in our Milwaukee office. And although all 3 of us spend most of our time north of the Packers-Bears rivalry border, we actually have content in this presentation that's going to cover both Wisconsin and Illinois arrest and conviction record, discrimination law, and recent developments in both of those states. So if you're a Bears fan and you feel like tuning out, please don't. We have some exciting information for you here as well. So we're going to start with this topic, which can admittedly be a little bit spooky for employers. I'm still in that Halloween spirit. But we'll start with Wisconsin law, which has been the more longer established of the 2 states when it comes to arrest and conviction record discrimination. For those of you who have employees in Wisconsin, hopefully you know that the Wisconsin Fair Employment Act prohibits employers from discriminating on the basis of arrest and conviction record. However, there are some exceptions, and there are the exceptions that really where we spend most of our time talking to clients and trying to get through whether or not these exceptions apply. The first exception is with respect to a pending charge that substantially relates to the job. So this relates to someone who has been arrested but not yet convicted of a crime. There is an exception to the extent that that pending charge is related to a crime that's substantially related to a particular job. And then obviously a criminal conviction that also substantially relates to a job is the basis, can be used in an employment decision and does not constitute arrest or conviction record here in Wisconsin. There are some specific statutory exemptions. Those exemptions are relatively narrow and they relate to things like burglar alarm installers, people working in an educational institution, people working in security. But for the most part, most employers will not have jobs that fall within those exceptions. There's also kind of a different area of the law that sometimes gives employers the ability to use an arrest and conviction record discrimination when there is not when there's not a substantial relationship, and that is when we're doing something called the Onalaska test. The Onalaska test is a court-created doctrine that says that if an employer does their own investigation into a pending crime, it determines that the crime has been committed without relying on the police file in that particular case, then that can be used by the employer to make employment decisions. So Sam's going to get into that a little bit later because that is the background for one of the new cases that's come up in Wisconsin that we think is interesting that we want to talk about today. So as you can see, because both of the exceptions to the Wisconsin arrest and conviction record, the prohibition on the use of arrest and conviction records in Wisconsin, rely on this substantial relationship test. The question of what is and what is not substantially related is really important. So Sam's going to get into that in a little bit of detail about what that substantial relationship test actually means.
Thank you, Scott. The substantial relationship test is really the fundamental concept behind this arrest and conviction record discrimination statute. And the substantial relationship test has us evaluate the elements of the actual specific statutory crime against the specific circumstances of the job for which the individual is applying for or holding at the time of conviction or arrest. Specifically, we're looking at the behavioral traits that are revealed by the specific crime compared to the circumstances tied to the specific job, those circumstances which foster potential activity. And so the substantial relationship test really has us focus our attention on the material aspects of the crime and the job. It is human nature, I think, for people to look at a crime and have a natural sort of impulse about how to perceive that crime. We deal with heinous crimes all the time that come across our clients' desks, and it's really a common mistake for people to rush into judgment about the actual relationship or lack thereof between a crime of conviction or an arrest and the job. So this substantial relationship test is very, very key to understanding what is lawful and what is not when considering convictions and arrests. We have a few examples here for you on the screen. Battery, child pornography, and DUI. Battery, substantially related to a job which entails working in a position of trust with vulnerable people. That job would not, however, be substantially related to something such as a cashier. Child pornography, by any accounts, a heinous crime, substantially relates to a job involving unsupervised access to children or the internet. I've had a case where an employer discovered a child pornography conviction in a background check. The individual had received a job offer, but after this background check, that job offer was rescinded because of a series of child pornography convictions on his record. The employer decided to rescind that job offer. That individual filed a complaint with the ERD, and the ERD found probable cause for discrimination, and that's because this individual's job was something of a mixed warehouse delivery job, and the position did not involve really, except for very, very tangentially, any interaction with children. And so despite the fact that we have this and the client, had this, reaction to child pornography as a heinous crime, they still found themselves in trouble with the law because of that decision. DUI, substantially related to a job involving driving or access to alcohol. This is a pretty common situation for employers, at least in terms of conviction, record discrimination. I've had another case, an individual had one conviction for misdemeanor DUI on their record. The employer declined to hire this individual. Again, the ERD found probable cause for discrimination. Why? This person's job only tangentially, again, involved driving in a delivery capacity, and that was not enough, at least according to the ERD and its initial investigation, to permit discrimination against this job applicant. 2022 was an important year for arrest and conviction record discrimination law. The landmark case that Eric mentioned already is Cree versus the Lurk, a Supreme Court case that came down in March 2022. This is a case where many of us in the defense bar and those who represent management side employers, we've been monitoring this case for a couple of years. The genesis of the case, 2015, it's a case which kind of had like a seesaw history with the ERD finding probable cause. The ALJ, the administrative law judge, did find that the conviction substantially related to this position. And then from there, between Lurk and the Circuit Court and the Court of Appeals and then finally the Supreme Court, every single level had a different outcome, different holding for this case. And so what is this case about? Historically, Lurk had generally had an exception to the substantial relationship test for domestic violence crimes. They had determined that crimes committed in the domestic context were not generally substantially related. There were very, very few exceptions to this, but it was mostly a blanket rule that these domestic crimes were not substantially related to most jobs because they were indicative only of violence toward an intimate partner or another individual in the domestic context. And historically, Lurk had determined that domestic circumstance meant that it was unlikely that individuals would recidivate or reoffend. Thank you. Mm-hmm. Reoffend in the workplace. This obviously caused difficulties for management because domestic violence is, regrettably a extremely common circumstance. So the instances of people who have these convictions on their record are many. And so the Supreme Court in this case determined, well, in the context of it, an applicant was offered a job that involved unsupervised customer and coworker interactions. The offer was rescinded when his domestic violence convictions were found during a background check. That individual turned around and filed a discrimination complaint with the ERD. And the procedural history of the case really reveals how difficult a decision this was. Ultimately, the Supreme Court held that the applicant's offer was lawfully rescinded, and in doing so, clarified, articulated the substantial relationship test in a new way, in that the substantial relationship test is fact-specific and should consider all material circumstances that represent opportunities for recidivism. The fact that a crime occurred in the domestic context, according to the Supreme Court, is immaterial. That's a circumstance that was not related substantially to the crime of conviction. Some circumstances that did relate to the crime of conviction: an opportunity to isolate victims, a willingness to use violence against others and to control others. This particular job was a job where the individual would have access to secluded areas, which allowed noise, which could potentially, according to the Supreme Court, lead somebody to recidivate. And then also, this applicant was going to be working with individuals who had regular contact with customers in a conflict resolution role, so he was going to be challenged. And according to the Supreme Court, they determined if you're going to be challenged and you have this domestic violence conviction record history, those behavioral traits revealed by the domestic violence conviction may reoccur in the workplace, notwithstanding the fact that it happened in the domestic situation. Moving on to the second case that came down this year. This was a Court of Appeals case from April 2022. It involved an employee who had been convicted of misdemeanor child sexual assault and who had pled to felony charges. Those felony charges resulted in what's called a deferred judgment against the individual. This individual was sentenced to, I believe, 90 days in jail with work release, Huber release. This individual told his employer about his convictions and about this criminal history. The employer, was making accommodations for this individual, but then this individual transferred to a sister company, and in the course of transferring, had to undergo a criminal background check. The criminal background check obviously revealed the crimes of conviction and the deferred judgment agreement. On advice of counsel, the employer underwent that independent investigation, the Onalaska investigation that Scott mentioned at the beginning here, named after a 1984 Court of Appeals case, and came to the conclusion that this individual did indeed commit the criminal conduct leading to the arrest and conviction. And so they made a adverse employment decision against this individual. This individual then sued, and again, in a seesaw sort of procedural history, the ALJ determined that there was discrimination, and then ultimately the Court of Appeals determined that while there was discrimination based off of the individual's conviction history, the misdemeanor charges, the deferred judgment was actually an arrest, classified as an arrest. And because the employer implemented this Onalaska investigation, availed itself of this Onalaska defense, the Court of Appeals determined that there was mixed motive for the adverse employment action. And so while on one hand, the employer did something which was unlawful, discriminate based on the conviction record, they properly availed themselves of this Onalaska defense by investigating the arrest record. And because of that, the Court of Appeals decided that the applicant was not entitled to back pay or reinstatement, but because there was a mixed motive, he was entitled to attorney's fees and an injunction to stop discriminating. We're going to now talk about the Illinois law.
Yeah, so thanks, Sam. And so I mentioned Illinois law. If you had asked us a few years ago, the Illinois arrest and conviction record law didn't necessarily exist. In 2021, conviction record discrimination did become part of the Illinois Employment Discrimination Act. So just like it is in Wisconsin, discrimination on the basis of conviction record is now a basis of employment discrimination in Illinois. As you can see from the slides, the test is actually relatively similar. It prohibits employers from discriminating on the basis of conviction record, but there are exceptions, and one of those exceptions is a substantial relationship between one or more previous criminal offenses in the employment that sought or held. So substantial relationship, that is exactly the same test that Sam was talking about earlier that we use here in Wisconsin. Mm-hmm. There's also this separate part here that talks about an unreasonable risk to the property or safety or welfare of specific individuals or the general public. So what do you do in Illinois when you're looking at that substantial relationship test? We talked a little bit about how in Wisconsin, it's more of a focus on the circumstances of the crime itself, and without oversimplifying it a little bit, about the opportunity for the individual to sort of reoffend with respect to that crime in the workplace. That is part of the test, but it's not really. Illinois really looks at it as more of a totality of the circumstances type test. So Illinois employers are required to consider the following factors when evaluating that substantial relationship test. There's first, the length of the time since the conviction. So if someone has committed a crime, but it's 20, 25, 30 years away, that would necessarily weigh against taking that crime into account when making a decision on somebody's employment status. The number of convictions that appear on the conviction record, presumably someone who has more criminal convictions would be more of a risk than someone who has fewer. The nature and severity of the conviction, obviously, the individual facts and circumstances surrounding the conviction, the age of the applicant at the time, and then any evidence of rehabilitation efforts. If an employer goes through that test, and you're required as an Illinois employer to go through that test before taking conviction record into account, and you still decide that you want to disqualify the individual based on that conviction record, you have to go through a process. Now, for those of you who use a third-party background check service, this process will seem relatively familiar, but keep in mind it's not the same. So if you are using a third-party background check, you still have to follow the Fair Credit Reporting Act requirements of pre-adverse action notice and final notice, in addition to these Illinois requirements. And we can have a discussion about whether or not those should be in the same notice or not. I would argue that they should probably be separate notices, but the requirements really are separate. But the concept is the same, which is in Illinois, if you're going to disqualify somebody from a conviction record, you must first provide them with this pre-adverse action notice, which includes a basis for the decision. So you must say on what basis you're making this decision, because you were convicted for X, Y, and Z crimes. A copy of the criminal history report, if you have one. An opportunity for the individual to provide evidence to respond to why they believe that they should not be disqualified on the basis of this conviction. And then you have to provide them with at least 5 days to be able to respond to that. And the idea here is that you have not actually made the decision to disqualify someone at this point. It's a preliminary decision. Once you've let those at least 5 days expire, you've presumably reviewed any material that the individual has provided to you if they choose to do so during that time. You can then make the final decision about whether or not you're going to disqualify somebody. And if you do, you must provide them with the final written notice that they've been disqualified. That written notice must include any remaining procedure they have to dispute that or discuss that with your department. And notably, a notice of their right to file a case with the Illinois Department of Human Rights as a potential conviction record discrimination case. So a real disincentive to disqualify someone on the basis of conviction record, because if you're going to do that, at the end of it all, you're going to have to provide them with a piece of paper that says that they have a right to sue you under Illinois law, and it has all the contact information that they need to do that. We have a few minutes left, so what I would really like to do is transfer over to Melissa. Now, Melissa, you used to be in private practice. We're working in-house for a while. Yeah. When you look at this from an in-house standpoint and now advising clients from a law firm perspective, what are some of the practical considerations that you think about when you're dealing with a tricky arrest and conviction record discrimination for an employee or for an applicant?
Yeah, thank you. Thank you, Scott. So, I think that generally these are all really good news points for employers. After CRE, for example, after Vega with the Illinois advancements as well, employers may lawfully base employment decisions, for example, on domestic violence crimes, which was not available to them before CRE without significant risk. So there are, I think, a lot of opportunities here. The one thing I would say to employers, I think that's really important, is these are only as good as what your documents say about them, right? So when you go through this determination of this substantially related, certainly an opportunity to get legal advice, privileged legal advice about what those points should be, about why the job is substantially related to the elements of the crime that the individual's committed or is has been arrested for. But then there's also an opportunity to put that into writing and ensure that that's part of the decision-making file in terms of why you're dispositioning a candidate potentially. So I think these are all really good news and opportunities, frankly, for employers to the extent that we utilize them. Now, certainly enforcement agencies could still find domestic violence crimes or other crimes do not substantially relate to the job. But the agency's determinations may no longer be based on this sort of illogical domestic violence exception, at least in the case of CRE. So again, still needing to conduct those individualized assessments of the pending or charges or convictions. So to the extent that employers hire employees in ban-the-box jurisdictions, have employment applications that mention criminal records, disposition prior to a conditional offer of employment, certainly consider either if you're an HR, somebody who's working within HR, or if you are in a legal department or outside counsel. It's really an opportunity to, I think now, given these new laws, to talk about what your HR procedure is as it relates to your hiring process. And also to, require that individuals or suggest that your HR partners obtain legal input on that substantially related test and do that under privilege. A couple other just sort of practical considerations. Not all employers are created equal when it comes to, what types of things they need to consider when making hiring decisions. So, for example, insurance and financial services companies have statutory or regulatory requirements that they're required to consider before making an offer of employment. So those need to be considered in addition to whatever state and local law might apply to them. Also, your employees require bonding and, what types of arrests or convictions are still bondable in that insurance and financial services situation. The other one I want to mention, and those are questions that you could talk about with your insurer for sure, and get answers to those, particularly in this tight labor market. There are going to be situations where you really want to extend an offer, but the individual might have something in their background that could preclude them from being bonded. So you might want to consider those types of things. The last thing I wanted to mention is just a note about some activity that I've heard about, haven't been involved in, but serial litigants who are trying to bait, frankly, HR individuals by discriminating against them because, frankly, they want to collect a check. And so, for example, if you hear something from an applicant like, oh, did you see my sexual molestation conviction on my record, and they say that to you during the course of the hiring process, of course, your first reaction is going to be like, no, and, we shouldn't hire you, and potentially, to maybe disposition that individual. To the extent you hear something like that, that no one would really ever tell you during the course of a, hiring process, definitely follow your gut feeling on that. Take a step back, pause, involve legal. That might be a situation that is really created by plaintiff's counsel, by a savvy defense attorney, criminal defense attorney, to result in a check payable to the plaintiff and to that lawyer. So just be careful for those things because they are out there, and certainly want to watch out for those to the extent they're setting traps that we could fall into.
And I'll just add one more thing is that, Wisconsin and Illinois are a little bit unique in having these types of laws. There are other states out there that also have arrest and conviction record laws, but many of them don't. So especially if you're in an HR or legal role in these states, but the people that you report to are out of state, sometimes they're not aware of the fact that they can't. For example, I've run into it a number of times with your child pornography type things where they would just automatically disqualify somebody because there would be no issue with that in another state. So really, making the people that you work with aware that we do have these kind of unique twists from an HR standpoint in Wisconsin, Illinois, I think is really important.
Definitely.
All right. And with that, we'll send it back to Eric. Thanks, Eric.
Thanks so much. Really appreciate it. Scott.
Melissa, Sam. It's a really fascinating topic, one I know that our clients are, as I mentioned on the top, dealing with and considering a lot right now, in particular because it is harder to find really good talent. And I think, Melissa in particular specifically alluded to this. If you have a business that operates and has a practice of conducting background checks, scrutinizing, criminal record, and have done that sort of fairly aggressively historically, we actually have some clients that are saying, hey, should we be more strategic in sort of the positions for which we're doing these sort of, stringent background checks? Perhaps we don't need to do, the more detailed criminal background check for employees who are going to be production employees, for instance, who are just going to be working in a production facility with other employees present. We may still want to preserve that process for employees who are in, situations or job descriptions where they're going to be interacting with finances or confidential information. Maybe we still want to do that for executive or high-level employees, but to give some consideration to whether we actually need to do that for all of our employees. We don't have this as a topic today, but something that's related to that is drug tests. Similar thing that I see going on right now, particularly as we're seeing a relax towards marijuana across the country, although not here in Wisconsin, of course, but more employers who have historically had prohibitions or multi-panel drug tests that they conduct on the front end for employees are now starting to say, listen, we're having a hard time getting talented employees in the door. What we're going to do instead is remove THC, for instance, from that drug panel. So, background checks, drug tests, all things that we see employers considering or thinking about being creative in order to, still attract and retain great talent. With that, we're going to move on to our next topic. This is one that I think, again, many employers struggling a lot with these days, particularly coming out of COVID. Our next group of presenters is Laura Malugade, Caitlin Doyle, and Quinn Steigers. All three are associates here in the Milwaukee office, although Laura will be receiving a well-deserved promotion to partner in just about 2 months. They will be discussing this complex and confusing topic of how to effectively manage mental health-related accommodation requests. Laura, take it away.
Thanks, Eric, and thanks all of you for joining us today. We're really excited to have you. My name is Laura Malugade, and I'm here with Quinn Steigers and Caitlin Doyle. And like Eric mentioned, we're going to be talking about, a pretty hot topic, I think, these days of, managing and addressing mental health accommodations in the workplace. I don't think it's going to come to a surprise to anyone joining the call today here that we've been seeing mental health issues just skyrocketing in the workplace. We're all working with clients on a daily basis with these issues, and I honestly think they're one of the most challenging things that are facing you all right now from both a practical, logistic perspective and a legal perspective as well. Coming out of the pandemic, so many people are struggling with mental health issues, and in particular, we're seeing a rise in disability discrimination claims related to anxiety and depression. In fact, the EEOC just released some statistics showing that disability claims related to anxiety have more than doubled in the past 10 years. In 2010, it was, approximately 5.5% of all disability discrimination claims related to anxiety, and now it's nearly 12%. And on a more global scale, disability discrimination claims of all kinds also are on the rise. So, we're now seeing approximately 40% of all EEOC charges are disability discrimination related claims, which is second only to retaliation claims. And, is certainly something that we need to be paying attention to and really think about carefully here. So if you need more of a reason to really care about and think about this issue, there's no shortage of recent headlines that you will see where these sorts of issues are making national news and resulting in significant financial liabilities to employers. So I'm sure many of you have probably heard about this birthday party lawsuit that made the news just this year, where an employee was awarded $450,000 after the employee claimed that the employer ignored an accommodation request not to hold a birthday party. So the employee had asked a manager and said, I have anxiety about this. Can you not hold this birthday party for me? Which is something they typically do. And the manager initially agreed, but somewhere in the process, there was a breakdown in communication, and they said, well, they forgot to relay it to the appropriate people. They held it anyways. The employee had a panic attack. Shortly after that was addressed by management and said, hey, what's happening here? What happened? And in that conversation, the employee had another panic attack and got upset and visibly angry, got red in the face, clenched his fists, and was shaking. Ultimately, the employee was terminated for making other employees feel unsafe because of that interaction. And as you can see, was awarded a substantial sum. Another case here that Caitlin's going to talk about more in just a few minutes is right here in our own backyard, the Eastern District of Wisconsin case with Judge Griesbach, who many of us regularly have cases in front of. There was a jury award of $125 million for failing to accommodate an employee with Down syndrome at Walmart. So, like I said, Caitlin will, talk about that more. But these are just a few examples of many that you can find that we're regularly working through with many of you, one of our clients, and hopefully addressing these things, and preferably before the decisions are made, to help keep you guys out of litigation if possible. But there's a lot of potential liability here. Caitlin and Quinn are going to take it over with some legal framework basics here that we should all keep in mind.
Thank you, Laura. So as many of you know, the Americans with Disabilities Act, the ADA, makes it unlawful for employers to discriminate against qualified individuals on the basis of a disability. And Wisconsin and Illinois state law both have that prohibition, but with some nuances in terms of the definition of a disability. But in general, disability discrimination would include failing to provide a reasonable accommodation to a known disability absent any undue hardship, and treating disabled individuals less favorably. So as you'll see in our chart, the definition of a disability under both federal and state law does include mental impairments, and it doesn't just refer to the actual mental impairment itself, but also to individuals who have a record of having a mental impairment and those who are regarded as having one, even if they don't actually. So you might be wondering what a mental health impairment is, and it includes a wide range of disorders. EEOC guidance refers to a diagnostic manual that has over 300 different disorders that could qualify as disabilities under the ADA. So these are going to include things like OCD, PTSD, anxiety, depression, and bipolar. And the EEOC has acknowledged that COVID-19 has and can make these worse for some people. And not only that, but long COVID could actually even be considered a disability under the ADA.
Thanks, Quinn. So now that we kind of know what a mental impairment is and what the ADA requires of it, we do have a duty to accommodate any mental impairment that is known. So this could include unpaid leave beyond a policy that is already established. It could require additional breaks, environmental changes, moving the employee to a less noisy area, and even remote work might be an accommodation. We see right now a case in Georgia where the EEOC has filed a lawsuit for a failure to accommodate a requested remote work accommodation. So this is something we anticipate seeing a lot more of with our clients as well. And this could even require some job restructuring. So under the ADA, which is federal, you do not have to change the essential functions of a job. If the accommodation would not allow the employee to perform all of the essential functions, it is not necessarily a reasonable accommodation. However, in Wisconsin especially, there's a little bit of nuance to this, because the question is whether the employee can perform most of the essential functions. So this might require some job restructuring or even removing essential functions of the job as an accommodation. As Laura mentioned earlier, this EEOC v. Walmart stores case that resulted in a $125 million jury verdict just happened pretty recently, and is a good example of kind of the hardships and the murky waters that an employer can find themselves in. As Laura mentioned, this employee had Down syndrome and had been working for Walmart for 16 years. Walmart was very well aware of this employee's diagnosis, and the employee had a schedule that was from noon to 4. She would take the bus to work, leave at 4, take the bus home, and one of her symptoms of Down syndrome is that she really struggled with changes to schedules. So when Walmart decided to change the schedules of numerous employees to better accommodate traffic of customers, her schedule was changed from noon to 4 to 1:30 to 5:30. Not only did this impact her ability to get to work and take the bus, but she also just really struggled to adjust to that new time. So she did request that Walmart return her to her noon to 4 schedule. This was denied, and after dozens of occurrences of tardiness or leaving early, Walmart did decide to terminate her. The jury found that this inflexibility that was needless deserved a multi-million-dollar award. So just definitely something to be careful of. And as you can see on this quote that we have on the screen, where the communication process might be a little difficult, employers have almost an additional responsibility to communicate with the employee to make sure an accommodation is made where needed. So now we move into the interactive process and medical documentation. So I'm sure we're all familiar with this interactive process language, but essentially it's nothing more than a dialogue between the employee and the employer to see if they can come to an agreed upon accommodation. The request for the employee to have an accommodation does not need to be formal or in writing, but when it is made, when you are alerted to the need of an accommodation, you have this duty to engage in this dialogue. You can request medical documentation to support that this individual has a disability that needs an accommodation, and this documentation can be requested from a healthcare professional. Now, this is not limited to doctors. This could include speech therapists, occupational therapists, physical therapists, nurses, PAs, the list goes on and on. So be very careful when receiving documentation to make sure that you do accept documentation that is from non-MDs.
And I'll just add here that, I think we see a lot of confusion here with people that we're working with, and they think, well, we can't ask for medical information. And while it's true that if you have a disability, someone has a very obvious disability, like, they're in a wheelchair and they're requesting a modification to their physical workspace, you shouldn't ask for medical documentation to support that request. But here in this context, with mental health issues in particular, it's not an obvious disability. We don't know. It is, arguably ripe for abuse of the system. And so we want to make sure that we do have a right to ask for medical documentation as to the existence of a disability and the need for an accommodation. So just something to keep in mind.
Yeah, absolutely. Thank you, Laura. And as Laura said, if it's not obvious and the individual does provide insufficient medical documentation, you are within your rights to request that the employee go visit a employer-selected healthcare professional to get that documentation that you may need. But you definitely should consult with legal before doing this. This is kind of a gray area and could put you in bigger trouble if it's not done properly. And additionally, technically, you do have this undue burden or undue hardship defense. That's a very high standard, so we definitely don't recommend relying on that defense in denying an accommodation.
Yeah, so the direct threat concept is not limited to the mental health context necessarily, but it can come into play when you're dealing with an employee whose mental health condition presents an unpredictable or even violent behavior. And this is because an individual is not entitled to the protections of the ADA if they pose a direct threat of harm to themselves or others. And again, like Caitlin mentioned with the last defense, this standard is also pretty high. It's going to require a significant risk of substantial harm that can't be eliminated or reduced by a reasonable accommodation. This determination also has to be based on medical judgment, and it can't just be based on stereotypes related to the disorder or fears of the employer or other employees, which can also get complicated then when there's conflicting medical information available. So if this is a defense that you're hoping to use, it would have to be pretty carefully crafted.
That's right. And I would say too, we see this a lot where, employees feel threatened or, unsafe. And even in that, birthday party example we talked about earlier, that was the stated reason for termination. And, I've regularly had people call and say, well, why can't we terminate if, people are feeling threatened and unsafe? Well, this is an option, but it is tricky, and we definitely recommend that you get the appropriate HR and legal folks involved.
So the last thing we're going to touch on substantively today is mental health impairments and misconduct. So under the ADA, which is, once again, federal, you may discipline an employee for behavior that is related to a disability as long as the behavior would be disciplinary if the individual did not have a disability. So it has to be an equally enforced standard. It also has to be job related. So in an instance where you have an employee who might be coming to work disheveled due to a anxiety or depression diagnosis, and they're violating dress code, but they are not customer facing or even really interacting with employees, the EEOC would likely find that that's not a job duty that is required of them, and so therefore you should not discipline on that violation. However, in Wisconsin, the standard is a little different, and you may not discriminate against an individual with a disability if the behavior is mental health related, and you know that that behavior is related to that disability. So that can kind of get you into murky waters as well. So we recommend contacting legal if this is one of your employees.
All right, so now that we have given some background on the law, we're going to talk through a scenario. So this first scenario is Corey. Corey has been struggling to stay focused at work. Following a string of unexplained absences, Corey's supervisor notified them that they would receive a written disciplinary warning. Corey informs the supervisor for the first time that they have been depressed and just can't handle the pressure of being at work. Corey explains that their absences were due to the depression and requests that a supervisor not issue the warning. Corey provides a note from an acupuncturist that Corey was diagnosed with major depression. The note also says that Corey needs to work from home 2 days per week. Management tells HR that they need Corey at work and not working from home. So what do we do? And this first question will go to Laura. Should you rescind the attendance warning issued to Corey?
Yeah, so this is actually a really complicated scenario. And I think we could spend a lot of time just talking through these issues. But whether you should rescind the discipline or the warning that was issued is going to depend on a number of different factors. So I think of kind of two legal issues here. There's, is there intentional disability discrimination? And is there a failure to accommodate? So from an intentional disability discrimination perspective, in this scenario, the employer didn't know about the alleged reason for the absences until after the discipline was issued. And so we likely don't have a problem on that front. I guess a little bit trickier question comes from a failure to accommodate perspective. So, under the ADA, employers generally do not have to accommodate, erratic or unreliable attendance where attendance is an essential function of their job as a reasonable accommodation. So, we don't know from this fact scenario what job Corey had, but, it's very possible that, saying, rescinding that written warning wouldn't be considered a reasonable accommodation. However, one thing to keep in mind is, if we work through this process and end up requesting additional medical information from Corey, and if Corey is able to provide medical documentation from an appropriate healthcare provider, that says, well, I was treating him and he was in a depressive state on these dates, and that's exactly why he was absent, then, maybe a more conservative approach would say, okay, do we want to, take, just go ahead and rescind this and manage the situation going forward? Or, a more aggressive approach might be to say, well, various different, considerations that we could take into play there. But, ultimately, it's not, unfortunately, a black and white answer, and which I think you're going to see with basically all these questions. So,
Yep. So the second question is, can you require Corey to go to a healthcare provider of the company's choice to substantiate their need to work remotely?
Yeah, this is also a really practical question regarding, when an employee provides a note that says they have depression from an acupuncturist, is that sufficient? An acupuncturist probably doesn't have the qualifications to diagnose major depression. So you might be able to request that Corey provide sufficient documentation from a healthcare professional that would be able to make that diagnosis and educate on the impairments of that diagnosis. But once again, you definitely should consult legal before you request the employee go to a provider of the employer's choosing to make sure you don't step on any of those legal landmines that might result.
Awesome. Thank you, Caitlin. And then the last question is, are you required to allow Corey to work from home 2 days per week?
So this is the $64 question. So we are all dealing with this question from clients all over the place right now. And again, it's going to depend on a number of different factors. But really, you need to think about the functions of the particular employee's job duties, whether those can be performed at home or not. You know, obviously, if we're dealing with production employees, line operators, it's not an option. But if we have an accountant who's been working from home remotely for the last 2 years successfully, that's going to be a different analysis. We're seeing that argument made, you know, a lot now, and it's making it harder for employers who want employees back to be physically on site to deny those requests. So, you know, not too surprisingly, we would need to get more information about this person's job, the history. What have you done with other employees in that, you know, similar position? Have you let other employees work from home remotely or not? And then we would want to go down the path of getting medical documentation and saying, you know, do you have sufficient documentation showing that you do have a disability and that working from home is a medically necessary accommodation for that disability. So it's, you know, it's a long process that can unfortunately just take a while to work through, but, you know, we do have tools at our disposal to use that we should make sure that we are implementing. So just in the interest of time, we'll skip to the very end here. You know, big picture, as you've heard today, this is a tricky area. Accommodations in general are tricky, even taking mental health issues out of the picture. And then you add on that additional layer of issues and challenges that come with employees dealing with mental health issues, and it becomes even more complicated. I think a key takeaway is that we just can't be rigid and inflexible with our policies, like we saw in the Walmart decision, and the EEOC really, you know, pushed the fact that it was a rigid inflexibility that is what caused the issues at the end of the day. So, you know, it has to be fact specific. We have to make sure we're doing an individualized analysis, and we need to make sure we're training your managers to recognize these issues, and so that they're appropriately escalated and that they can get to appropriate HR and legal to make sure they're addressed. So thanks again for joining us, and I'll kick it back to Eric.
Thank you, Laura, Caitlin, Quinn. Excellent job. Really interesting stuff. Laura started off by talking about that quasi-famous case about the surprise birthday party. Laura is actually one of my best friends here at the law firm, and I surprised her one year by walking into her office with a trumpet and playing Happy Birthday. She seemed to experience some shock when I did that, thankfully. I have not yet seen that lawsuit filed against me or the firm, so we'll hope it stays that way. As we transition to our next panel, we're actually going to do our very first poll question. We have poll questions in here so that we can satisfy those requirements in some of the states that require them. You may notice that these poll questions are not directly related to the substance, but maybe they'll be just a little bit of a fun break for us. So our first question, and I'm interested in hearing sort of or learning the consensus of the group, what is the best winter comfort food? First is chowder/soup, pizza, macaroni and cheese, cheese curds, or chocolate/candy. Please go ahead and select. And I guess we'll see if the Wisconsin audience here lives up to our billing as true Scotties. Give you a moment for you to select, enter your selection, and then my AV team here will push through my results so that I can see what the consensus of the group is. Chowder/soup. That's actually really excellent. So we have a lawyer here at the firm. Some of you may have interacted with him. His name is Dan Miskey. Dan is the world's biggest fan of Real Chili. Real Chili, an iconic chili restaurant here in Milwaukee. 2 locations, one near the firm's old offices and one on the Marquette University campus. Real chili is, how would you describe that? An acquired taste. So he has a tendency to always bring the new lawyers with him when they're making treks to get that, especially when the weather gets cold. So I like the results. Thanks for participating. And we're going to move on to our final Wisconsin panel here, where we're featuring Jeff Trottier and Tom O'Day. Jeff is a partner in our Milwaukee office. Tom, a partner in our Madison office. Our colleague Betsaida Zudi, who is an associate in our Madison office, is also scheduled to join us today, but is unable to be with us because of an illness. I suspect she's watching and wanted to extend our well wishes to her. Look forward to seeing Beth at the next L&E presentation. So Jeff and Tom will be talking about the extremely timely topic of possible changes for Wisconsin employers as a result of the upcoming midterm elections. So Tom, I'll turn it over to you.
Good morning. I'm Jeff Trottier. As Eric said, I'm an employment lawyer out of our Milwaukee office, and I'm here with Tom O'Day, my colleague from the Madison office. So if you follow Wisconsin politics at all, or have at least turned on a radio or TV or gone online in the last 2 years, you know we have several hotly contested races for governor, lieutenant governor, attorney general, several state legislative seats, and of course, a U.S. Senate seat. So depending on how things shake out over the course of the next week or so, we could see a lot of changes in several very hot areas of employment law. So today we are going to focus on, first of all, leave laws. Are we going to change our beloved Wisconsin Family and Medical Leave Act? If we go around the clock, wage and hour, my favorite topic, which no one understands, but if you practice it, you love it. The perpetual will they or won't they question of marijuana legalization in Wisconsin, both medically and recreationally. Some changes to disability laws that are going to interest employers. Abortion law in a post-Hobbs world, and our new old friend, COVID-19 vaccination. So without further ado, what to expect when you're expecting post-election changes in employment law. You see what we did there? So a little bit further on this proposed legislation and what do we really know about employment-related proposed legislation in Wisconsin. These topics really do range from the mundane to the controversial to the potentially paradigm changing. Abortion and reproductive rights. In the employment space, we're going to look at how that changes benefit provision and payroll tax. For marijuana, both recreational and medicinal legalization in the state, and how that's going to affect employers. COVID-19, a couple of really interesting changes on that front. We're going to talk about vaccine mandates. Could those be prohibited? And what I find fascinating, vaccination status as a protected class. Because, and correct me if I'm wrong, Tom, but protected classes we usually think of as something that can't change. With degradation rates of vaccines, they can. So what would that look like? As far as disability discrimination goes, there's a proposed joint resolution that could make things a little bit different, be a little bit of interest to employers. For leave law, there could be changes affecting our state version of the Family and Medical Leave Act. And for, again, wage and hour law, where are we going with bridging the minimum wage and bringing it closer to a living wage? Are we going to go 2 steps forward? Are we going to go 2 steps back? We have options for both. So with that understanding, first let's talk about abortion law. Wisconsin law on abortion, as you can see, was first passed, and we had this law existing from 1849, and it prohibits abortion unless it's necessary to preserve the life of the mother. Unlike several states, there's no carve-out for incest or rape. So on June 24th of this year, the United States Supreme Court held that there was no constitutional right to abortion, so overturning almost 50 years of precedent established by Roe v. Wade. So now it's up to each individual state. What are we going to do regarding abortion regulation? How does that affect employment also? So we have 3 pending laws or proposed legislation that you can see on the screen. Assembly Bill 1064, which is also Senate Bill 923. That would permit the mother, the father, the grandparent, or any family member, like a sibling, a cousin, to actually sue the abortion provider for a minimum of $10,000, not a maximum, but a minimum. So we don't know what the top level of this lawsuit could range for. And it also requires healthcare providers to require a patient considering an abortion to listen to the fetal heartbeat. Senate Bill 260 affects primarily the University of Wisconsin system and their hospitals and clinics, where stating they would be prohibited from performing, assisting in the performing, or training on providing abortion services. So this would reach into the University of Wisconsin Med School curriculum. It also states that they could not provide liability insurance to any healthcare providers that would cover abortion services. It does make exceptions for the health of the mother, rape and incest. Then Assembly Bill 593, Senate Bill 591. This is primarily an information and informed consent law. It would require a doctor to provide information about continuation of the pregnancy and how to counteract any drug-induced abortion before the second dose. It also requires reporting of information to track how abortions are paid for throughout the state. This information would be summarized by hospital and clinic, whereas previously it was just summarized more anonymously. So the state of reproductive rights in Wisconsin appears to be highly dependent on the outcome of the next election within a week. So all of these proposed pieces of legislation had been, they failed to pass pursuant to a joint resolution, but they were primarily sponsored by the legislators that we expect to retain their seats. So we probably will see some or maybe all of these again in the next several years. And in a post-Hobbs world, they might gain some traction. We'll find out. The campaign platforms and statements from candidate Michaels and Governor Evers also provide some insight. Michaels has recently kind of doubled down his prior campaign statements where he unequivocally supported Wisconsin's 1849 abortion ban, without exceptions for rape or incest. On the other hand, Governor Evers has been very clear about his stance on reproductive rights. In the past year alone, he's vetoed 5 bills which would have aimed at restricting abortion rights. Also in June of 2022, Governor Evers and Wisconsin Attorney General Josh Kaul filed a lawsuit challenging this 1849 law. So what does this really mean for employers? Because that's what we're here to talk about. If you are in an abortion ban state, consider whether you have a self-funded plan that would be subject to ERISA. That means we look to federal law for our guidance. If you're fully insured rather, and you have a purchase plan, then you're going to be subject to state law. So you're going to look at state law for guidance. If you're a multi-state employer, so you have employees in several states, you'll need to be cognizant of what those states' laws are if you are not a self-funded plan and you are fully insured. Some employers have considered providing travel benefits to states where abortion is legal. You'll have to consider the tax implications to your employees as well, and how will that affect their payroll tax. The Family Medical Leave Act may provide care or leave for abortion care that may be available. We'll need to watch and see if our Wisconsin Family Medical Leave Act is also similarly amended to affect that either way. So from there, I'm going to move on to the next slide, and Tom's going to take it away.
All right. It's hard to believe that a year ago we were all dealing with and frankly worried about the COVID-19 vaccines and the mandates that might have coming from the federal government. We, in the last year, have not had any legislation that has been enacted to prohibit those COVID-19 mandates. That said, there's not a lack of trying. Our Wisconsin legislature, as you can see in the first referenced proposed legislation there, had attempted, and the Assembly actually passed legislation that would have prohibited any employer mandate for a COVID-19 vaccine in the state of Wisconsin. If we do have a new Republican governor in the governor's mansion come November 8th or when the inauguration occurs, that is legislation that is likely to pass in the state of Wisconsin. that legislation, the top one referenced there, is specific to COVID-19 and the other variants of COVID-19. But that legislation is likely to pass, which, if there's a Republican governor, will put Wisconsin employers in somewhat of a bind. That said, there are other states across the country that are in this similar position, and employers in those states have had to manage the state law on one hand that says you cannot require or mandate a COVID-19 vaccine, and a potential federal regulation or law for those, for example, in healthcare that requires such a mandate. And there's some guidance there, some availability for employers working with their legal counsel to manage that scenario.
Tom, do we have any idea what could happen if Governor Evers stays in the governor's mansion? Do you think that we would still, this likely to pass legislation would still be in effect?
I think almost certainly not. And though Governor Evers didn't have to veto this legislation, the Republican Senate never took this legislation on, the governor would almost certainly veto any COVID-19 vaccine prohibition.
Interesting.
The second referenced legislation that is on the screen there is not specific to COVID. And this was legislation that would have added vaccination status as a protected characteristic under Wisconsin law. It would have protected vaccination status under the Wisconsin Fair Employment Act, along with things like race, religion, disability, and other protected characteristics. It would also have prohibited discrimination based on vaccination status and things like housing discrimination laws and student non-discrimination laws. This legislation was interesting. It had a hearing in the Wisconsin Assembly. A lot of people from the medical freedom world and grassroots activists showed up for the hearing, and the Republican-controlled committee did pass this through the committee. The Wisconsin legislature at the state assembly level did not take this legislation up and did not push it through to the floor of the assembly. There weren't a whole lot of business groups that were against this legislation in committee. I suspect, without knowing, that behind the scenes, some of the larger business groups in Wisconsin were really pushing back against this proposed legislation to add the protected status of vaccine status to discrimination laws. That would probably put employers in Wisconsin in a pretty difficult situation, again, with respect to federal law that might otherwise require vaccines. For healthcare providers in particular, we're worried about the COVID-19 vaccine, as well as other flu and other vaccines that they need to have in the workplace for safety purposes. With respect to disability-related laws, Jeff mentioned the resolution that the Assembly passed and the legislature passed last year that did protect individuals with disabilities and promoted individuals with employment opportunities in the workplace. Under the former Republican governor, Scott Walker, there was additional money added to programs like Project Search, a program through the Department of Workforce Development where partners in the employing community could work with the department to employ individuals with disabilities. I expect if the Republican legislature stays and there's a new Republican governor, more money will likely be made available, and employers should take that opportunity to employ those individuals with disabilities. Likely, if Governor Evers is reelected, I suspect there will be more money put toward those kinds of programs to employ individuals with disabilities. As you in the crowd from Wisconsin know, our state disability discrimination law differs in pretty important ways from the federal Americans with Disabilities Act. And what potentially could happen with the Republican legislature and a Republican governor is a movement toward federalization of state disability discrimination laws. The Crystal Cheese Lake case may be something that comes to mind. It's a famous case in Wisconsin where our state Supreme Court said, our law is different than the Americans with Disabilities Act. And even if it means eliminating or taking away essential functions of a job, that may be an accommodation that an employer needs to make in the state of Wisconsin. You heard our colleagues earlier speaking about some of the differences between Wisconsin law and federal law. If Republicans are reelected at the legislative level, if there's a new Republican governor, there could potentially be a movement toward federalizing the Americans with Disabilities Act or harmonizing the Americans with Disabilities Act and Wisconsin Fair Employment Act with respect to disability law.
And you know you're in Wisconsin when the watershed disability case relates to cheese.
Exactly, exactly. The Medical marijuana in the state of Wisconsin is pretty fascinating. The Marquette University Law School poll pretty regularly asks its questions about medical marijuana and recreational marijuana. As far back as 2019, 59% of the respondents in that poll backed legalization of marijuana. And in 2002, as late as August of 2022, there was not much difference or much movement in those numbers. So a full 59, 60% of the electorate in Wisconsin supports legalization. Back in 2019, they asked about medical marijuana and legalization of medical marijuana, and that number jumped to 83% of the respondents to the Marquette Law School poll. The Speaker of the Republican legislature in the Assembly, Robin Vos, has said he thinks at some point marijuana will be legalized in the state of Wisconsin. When that occurs is still a ways off. And Speaker Vos recognizes that. He himself is an advocate for medical marijuana with very specific restrictions. But he does think it will happen at some point. And he talks about the trend of those individuals in his Republican caucus who have moved from no legalization to warming up at least to medical marijuana. Governor Michaels, or candidate Governor Michaels, has said that he does not intend to sign any legislation that would legalize marijuana. So I think that issue is dead on arrival in a Governor Michaels administration. Governor Evers has already proposed in some of his previous budgets that money go toward medical marijuana and that the legalization occur in the state of Wisconsin. And he had proposed sending some of the money that's raised from the taxation of that, what would be legal industry, to the schools in the state of Wisconsin. So with respect to the election and medical marijuana, the decision really will make quite a difference. But the legislature, even if it's Republican controlled, which it probably is, probably is not yet likely there.
Okay, moving on to my favorite topic, as you can see by Oprah there, wage and hour. So you get a raise, everybody gets a raise, or some people don't. We have a 2 steps forward, 2 steps back approach here. So Wisconsin currently mirrors federal minimum wage law, $7.25 across the board. There is some proposed legislation where it would increase to $10.15 upon the effective date of that legislation. Every bill has an effective date. It passes on day 1, it's effective on day whatever. That date, it would go to $10.15. A year after that date, it would go all the way up to $15 an hour. So $10.15 to $15 an hour. Now, from a federal perspective, we know that Senate candidate Mandela Barnes favors $15 an hour. Senator Johnson does not. So as the debate progresses federally, we have kind of a clear understanding of the candidates' positions. Now, moving on to the other side, the 2 steps back, Senate Bill 286 would eliminate the separate tipped minimum wage for all employees. So currently, under Wisconsin law, we have this tipped employee minimum wage of $2.33, unless you're under 20 and it's your first 90 days of employment, and then your minimum wage is $2.13. As long as that employee is otherwise averaging out to minimum wage when you factor in their tips over the course of each week. So you have to figure it out every week. The proposed Wisconsin legislation would eliminate the requirement that employers pay any minimum wage to tipped employees. So that would just go away, and they would be living off of their tips alone. Now, it's not that big of a change, really, because most employers still are subject to the federal Fair Labor Standards Act. Under the Fair Labor Standards Act, there still is a tipped employee minimum wage of $2.13. So that minimum wage wouldn't entirely go away for the majority of employers. Moving on to paid leave. In Wisconsin, we have our beloved Wisconsin Family and Medical Leave Act, our slightly quirky, slightly different than the federal Family and Medical Leave Act. And we have proposed legislation that would change a few things there. The family definition would be expanded to include grandparents, grandchildren, and siblings. This is really a recognition that the family goes beyond just the traditional nuclear family that lives at home with you. As grandparents age, who have participated in the raising of their grandchildren, there's more of an onus on grandchildren as they come of age to step in that caregiver role. And this legislation kind of recognizes that. There's another form of leave that could be available under the Wisconsin Family and Medical Leave Act, which is active duty leave, very similar to the exigency leave available under the Federal Family and Medical Leave Act. There would be up to 6 weeks available leave for any exigency or emergency related to the foreign deployment of a family member who is a member of the armed forces. This may have certain leave tracking issues that come up for employers who track their state leave on a calendar basis, but on a rolling basis for federal leave. There also may be some issues and some wrinkles that HR professionals come up against when considering concurrent leave of PTO, because as we know under state leave, it's the employee's choice whether they want to exercise their PTO and also have paid leave. And then once you burn that state leave, then you get to federal leave, and then it's the employer's choice. We'll also have to deal with that when there's exigency leave now. Now, the biggest change in this proposed legislation is that the WFMLA, like the FMLA, currently applies to employers with 50 employees. Under some of these revisions, it would apply to all employers regardless of size. That's also important for multi-state employers who only have a few employees in Wisconsin, or maybe just one employee in Wisconsin. You now may have an obligation to provide state leave to those employees in those small shops. The final provision in this legislation would be a leave insurance program. Any covered employee and their family would be entitled to up to 12 weeks of leave insurance benefits if they qualify for family or medical leave, meaning really partial pay supplementation. This applies again to any employer regardless of size, and that employee would only have needed to work for 680 hours, not the 1,000 hours that we're used to under the WFMLA as it stands today. It also applies to self-employed workers, provided that they pay into the program. So the way this program is going to be funded is through a state trust fund, which we presume would be funded similar to unemployment insurance tax. So as long as that self-employed worker is paying in, they would have this paid supplementation eligibility. The supplementation would be somewhere between 66 and 95% of an employee's weekly earnings, capped at $1,000, depending on how much that they've earned. And with that, we've talked about paid leave, and I'm going to send it back to Eric.
Thank you, Jeff. Thank you, Tom. It's interesting how much the law could really change here in Wisconsin, and frankly in many jurisdictions, based on what happens next week. Tom made reference to the Marquette University Law School poll. For those of you who are political junkies and are not already tired of incessant political ads, I suspect the answer is there are 0 of you in that category. But those who are interested, at least, in following that, the gold standard poll here in Wisconsin is the Marquette University Law School poll. They are going to be releasing their final poll result tomorrow around lunchtime. You can follow their Twitter account. There will also be a video broadcast there. But the governor's race here in Wisconsin, and frankly, a number of legislative races that will impact those employment law-related proposals that Tom and Jeff just talked about, are in the balance, and it's a 50-50 coin flip in those races right now. Before we go south of the border and transition to our next group, we're going to do our second poll question. The next poll question is the famous 3 truths and a lie. 3 truths and a lie, Wisconsin trivia. Pick which one of these is the lie. First one, Governor Evers was born and raised in the cheese capital of the world, Plymouth, Wisconsin. Second, Governor Evers made history for a record number of vetoes in a single legislative session. 3, the Swiss cheese capital of the world is located in Wisconsin, not Switzerland. And 4, Wisconsinites have the highest rate of lactose intolerance in the United States. Which of these is the lie? I'll let you plug in your answers here. I'll have my AV team push this through so we see what the results are. You can read the 4th one. This is a lie. We knew that we would be cheesy today. I did not know we would be this cheesy. Let's move down to Illinois for our first terrific Illinois panel featuring Sarah Quinn and Jennifer Ralph. Both are terrific associates in our Chicago office. and they will be providing an overview of some of the significant changes to Illinois state and local employment laws that took place in 2022 and that you can expect in 2023. Sarah, over to you.
Thanks, Eric. I'm Sarah Quinn, and I'm here with my colleague.
Hi, I'm Jennifer Rell.
And we are going to talk to you about some Illinois developments. But for our Wisconsin-based friends, don't put us on mute just yet. We will cover some topics that have a greater reach than just our state of Illinois.
That's correct. So we'll give you a brief overview of what we're going to hit on today. We'll start with amendments to the One-Day Rest and 7 Act. We'll give you an overview of the first Biometric Information Privacy Act verdict that came down just a couple of weeks ago. We'll give you an overview of the Illinois Family Bereavement Leave Act, a recent decision out of the 7th Circuit on FMLA interference, and then we'll conclude with amendments to the Illinois Human Rights Act and the Chicago Human Rights Ordinance.
We are going to do our best to fly through these topics today. A little reminder of some Illinois greatness.
No promises, but we'll do our best. Let's start with the One-Day Rest and 7 Act. So as most of you are probably already aware, the One-Day Rest and 7 Act governs meal periods and rest requirements in Illinois. As the Act currently stands, employees who work 7.5 or more continuous hours are entitled to one 20-minute unpaid meal break within the first 5 hours of their shift. That is going to change slightly effective January 1 of this coming year. So come January 1, employees who work an additional 4.5 hours, so that means any employees who have 12-hour shifts will be entitled to another 20-minute meal period. What this means for you as an employer is that if you have employees who are working 8-hour shifts, probably not a lot of change in policy. If you have employees who are working 12-hour shifts, you're going to want to look at your policies and practices to make sure you are accounting for these additional meal periods.
Now, Jen, I haven't confirmed this, but I'm quite certain that this amendment was pushed through by the hot dog lobby. For those of you in Wisconsin, you're going to need to take note to get CLE credit. You will have to correctly identify all the toppings on a Chicago-style hot dog. And I know that can seem overwhelming, so just remember the cardinal rule, no ketchup.
I don't know if Sarah's run that by the CLE board, but we'll take her word for it. All right, the One-Day Rest and 7 Act also governs rest requirements. So keep in mind, this doesn't apply to all employees. So to the extent you have questions, definitely consult with your HB counsel about that. But for covered employees, currently required to have 1 day of rest in any calendar week. So that means you look Sunday through Saturday and ensure that those employees have 1 full day off. Again, that's going to change or be slightly modified effective January 1 of this year, or this coming year. So on January 1, employees will now be required to have 24 hours of rest in any consecutive 7-day period. So what that means is you as an employer now need to be looking at rolling 7-day periods rather than the calendar week. So from Wednesday to Tuesday, that employee needs to have a full day off. From Thursday to Wednesday, same thing. So you're no longer just looking at the calendar week. Similar to many laws, there's also going to be a notice requirement associated with the One-Day Rest and 7 Act amendments. So the Illinois Department of Labor will issue a poster, and you're going to be required to post that in your workplace. A bit unique to these amendments is they govern remote workers as well. So you're going to be required to either send this notice to your remote employees or post it where you regularly communicate with employees, so something like an intranet site. You might be thinking, do we really need to be in compliance with these requirements as of January 1? And when you look at the penalties that are now imposed for violations, I think you're going to realize the answer is yes. So currently under the Act, a violation is a petty offense, and it is subject to fines of $25 to $100. But effective January 1, those are going to significantly increase. Any violation of the Act is now going to be a civil offense. For small employers, so employers with less than 25 employees, the penalties are up to $250 payable to the Illinois Department of Labor and an additional $250 of damages payable to the employee. So that's a total of $500 in damages per violation. And then those fines double if you are an employer with 25 or more employees. So Sarah, what can you tell us to be thinking about with these employees or with these penalties?
Well, it's important to know what an offense is, right, Jen? The Illinois Department of Labor will consider each week of denied rest a single offense, each day of a denied meal break a single offense, and failure to post notice. And that could be per employee. So your damages could rack up quick.
Yeah, they could get quite exponential. And speaking of exponential damages, let's turn to the first Biometric Information Privacy Act verdict.
Yes, this is a big one, ladies and gentlemen. The first federal jury verdict on Illinois' Biometric Information Privacy Act came down just a few weeks ago, awarding the plaintiffs in this suit $228 million. The suit was Rogers versus BNSF Railway, and it was awarded to a class of 44,000 truck drivers. We're going to tell you a little bit about the facts that led to that claim, some key procedural notes, and of course the takeaways from this case. So first, Illinois has sort of a unique Biometric Protection Act, which requires several elements that a company must follow in order to ensure protection of your employees' biometric information. If you collect biometric information, that is certainly something we can help you with to ensure your compliance. But this case really stresses the importance of consulting with legal to avoid these kinds of damages. Here, the plaintiffs were a group of truck drivers who went to the rail yard to deliver freight, and a third-party vendor of BNSF called Remprex was in charge of securing the correct credentials to get into the rail yard. It was Remprex that was collecting the biometric information and storing it. Now, BNSF has sued Remprex in Texas State Court, but that case has been stayed.
So Sarah, when you say they were collecting the biometric information, they were scanning their fingers as a security measure, correct?
Yes, that's one way that companies frequently collect biometric information, is through a fingerprint scan. Others are retina scans or similar types of things. So in this case, after a 5-day jury trial, the jurors came back within roughly an hour, Jen, so a really quick result, finding BNSF liable for negligent and reckless and intentional violations of the law, which provide higher damages. Now, in this case, it's important to note that the judge issued damages per class member, not per scan, and we'll talk more about that in a minute.
Okay.
Now, BNSF has come out and said it will appeal this verdict, which tees up for our Seventh Circuit whether vicarious liability for an act like this will protect a company. Judge Kennelly denied the railway's request for an interlocutory appeal before the verdict, and BNSF did introduce this theory, but the jury didn't buy it. Got it. Now, let's talk takeaways, Jen. The most important and maybe the most obvious takeaway here is plaintiffs are now in an even stronger position to negotiate settlements before going to trial. Second, this verdict should serve as a big warning for companies who collect biometric information, even if it's third-party vendors that they work with. So we strongly suggest that companies thoroughly vet their third-party vendors and especially make sure that the contracts they have with those vendors include strong indemnity language and insurance policies. Now, we talked about damages, and this case has a huge damages figure. But unfortunately, these damages could get much, much higher. The Illinois Supreme Court has currently heard arguments in Latrina Cochran versus White Castle Systems about whether it's a per plaintiff or per scan damages calculation. So you can imagine how this jury verdict could multiply if the Illinois Supreme Court rules BIPA applies to per scan.
So you're saying there's the potential that every time an employee scans their fingerprint, there could be a new set of damages.
Correct.
Accrued.
Correct.
Okay.
Illinois has not ruled on whether a single scan is a single injury, which could multiply over every time that single employee scanned their finger.
So we'll be monitoring for that decision and, of course, release any alerts as soon as we see a decision on that issue.
Why don't you tell us about family bereavement leave?
Sure. So many of you are also probably familiar with the Illinois Child Bereavement Leave Act. Effective January 1, again, of this coming year, that Leave Act is going to be significantly expanded. So currently, employees can take leave related to the death of a child. So that is to either attend the funeral of a child, make arrangements necessitated by the death, or even just to grieve the child. But effective January 1 of this coming year, that is expanded so that employees can take that leave for any covered family member. So we'll show you there on the screen. The Act does define covered family members, and so when employees make these requests, you may want to confirm that it's a covered family member. There are a couple of notable missing family members that we flagged from this list. So a covered family member does not include your brother or sister-in-law or your aunt or uncle. There's also going to be an entire new category of leave come January 1 that employees can take bereavement leave for, and that is leave for pregnancy-related losses. And so I won't read to you every last category of leave, but just keep in mind there's several new categories that you might not have expected or have been aware of come January 1.
That's right. And Jen, I think it's important we note for our audience today that these pregnancy-related loss leave eligible events don't apply to a specific gender and also can be used by partners who aren't in a spousal or domestic partner relationship.
That's right. So you may be seeing significantly more instances of employees looking to use this protected bereavement leave in the coming year. So what can you do as an employer to try to put some parameters on this leave to ensure it is being properly used? Well, the Act already provided that employees need to give 48 hours notice of the leave if that's practicable. The amendments now clarify that employers also can require reasonable documentation to substantiate the leave. Now, you need to be a little careful because the amendments provide that employers shouldn't be requiring employees to identify the category of leave they need the bereavement leave for. The Illinois Department of Labor is going to be issuing a model form that should serve as reasonable documentation for this leave. So we'll be keeping an eye out for that because we expect that to provide some insight on what the department thinks is reasonable documentation. So again, we'll keep everyone apprised of those developments. Related to family leave, but on a different topic, Sarah's going to cover a recent 7th Circuit FMLA decision for us.
That's right. So Wisconsin-based colleagues, chime in again here. We're going to talk about a 7th Circuit decision that has to do with redefining or really clarifying the elements of FMLA interference. So in Zaccarelli versus Dart, Mr. Zaccarelli, the plaintiff in this case, suffered from a number of serious health conditions which required frequent use of FMLA. By September of 2016, he had used over 300 hours of his allotted leave. And plaintiff, in this case, wanted to seek treatment for one of his serious health conditions. And so he alleges that he called his FMLA manager and had the following conversation you can see in bold. He asked if he could take additional leave, to which case the FMLA manager allegedly said, "You've taken serious amounts of FMLA. Don't take any more FMLA. If you do so, you will be disciplined." The plaintiff then retired from the sheriff's department and sued, as they did. So what did the 7th Circuit say? Well, they reaffirmed the same elements. However, they really focused on element 5 here, which is the act of interfering, restraining, or denying FMLA benefits. The sheriff's office said, how could we have possibly violated his benefits? We didn't deny his leave request. But the court held that an employer can violate the FMLA simply by discouraging an employee from exercising their rights. Here is the language from the statute itself, which we highlight any attempt, any interference or restraining or denying the attempt of exercising someone's rights can be a violation under FMLA. So the court really focused on the plain text of the statute here.
That makes sense. So what should our employers be taking away from this decision aside from the legal decision?
Right. So tying it back to our colleague's presentation earlier on mental health accommodations in the workforce, it's important to know that that employees now have a cognizable claim for any discouragement of their use of leave. So it's really important that we are creating clear documentation in our employee records that show and document every conversation that has to do with any request of leave.
That's right. So that could even look like a note to the file, just memorializing a conversation.
Absolutely. And we can't stress enough the importance of training individuals who will receive these calls or requests so that the individuals inside the company can be alerted to this risk and make sure that those requests are well documented.
That's right.
All right, so finally, we're going to turn it to the Illinois Human Rights Act amendment and some Chicago-based ordinance harassment training.
Yep. So I'll be a bit of a broken record here, but come January 1, we have another amendment, and this time to the Illinois Human Rights Act. So as of January 1, the definition of race in that act is amended to include traits associated with race. So that includes hair texture and protective hairstyles, such as braids, locks, and twists. Illinois is unique in that it is joining, or it's not unique in that it's joining 16 other states who have passed this legislation that is frequently known as Crown Act legislation.
That's right. And Jen, it also passed in Congress this year. Is that right?
That's correct. It was actually introduced by Senator Cory Booker.
Which you'll notice from our picture, but it's interesting, Cory Booker cares a lot about hair rights, seeing that he has none.
And for our Wisconsin employers, you might just want to note that this legislation has not passed in Wisconsin just yet, but it was reintroduced in 2021. And finally, our Illinois employers who have employees working in Chicago, so whether that is they are physically in Chicago or they work remotely from Chicago, you'll want to be aware of the new harassment training requirements. So effective July 1 of this last year, all employers with employees in Chicago are required to provide annual sexual harassment training. And then somewhat unique to Chicago, they are also required to provide annual bystander intervention training. So for your supervisors and managers, that's going to mean that annually they need to receive 2 hours of sexual harassment training. All other employees need to receive 1 hour of sexual harassment training. And then on top of that, all employees need to receive 1 hour of bystander intervention training.
Mm-hmm. Now, it's important to note here, too, that all employees must be trained within their first calendar week of their employment. So it's really important that companies get this training together and are prepared to provide this training to their employees. Yep. Now, don't worry just yet. You have until June 30th of 2023 to make sure that your employees have either a cumulative total of 3 hours for managers and supervisors or a cumulative total of 2 hours for all other employees. And certainly your HB attorneys can help you either provide this training or we can provide the materials that you need to provide this training in-house.
That's right. And that concludes our Illinois updates. So we'll kick it back to Eric.
Thank you, ladies. Jen, Sarah, really excellent presentation. We're doing this presentation over the lunch hour, and that picture of a Chicago-style hot dog looked really good to me. In addition to being a labor and employment lawyer, I actually fashioned myself as a hot dog connoisseur. My family and I did a hot dog taste test about 2 years ago, and I can tell you the winner in that blind taste test was Chicago's own Vienna beef. Check it out the next time you're in the supermarket. They're not even a client. Maybe they should be. All right, one last poll question before we do our finer session. Who is the hardest worker at Husch Blackwell? These folks bill for a little bit less than the associates who might be working on your files. Berkeley, Emperor Menelik II, Tucker, or Penny. And I can tell you at least one of these dogs belongs to a member of the Labor and Employment PSC. We'll go to the next slide, which has your place to select. Tucker, Penny, Berkeley, Menelik. Does it even matter? They're all adorable. Or finally, I'm a cat person. Enter your selection. We have a cat at our house. We have a pandemic cat named Maxie, which we got in 2020. She's become a fast member of the family, and I'm getting allergy shots on a bi-weekly basis. The good thing is she comes and sits on my lap when the family's hanging out, so I think she understands the sacrifice that I'm making. All right, let's see those poll results. Does it even matter? They're all adorable. That's really the correct answer. Okay, thanks for sticking with us. Our final presentation today is Ann Mayette and Julie Garabedian. Ann is a partner in our Chicago office, and Julie is an associate there. They're going to be discussing some recent amendments to Illinois' pay equity law and what that means to employers that operate in the state. Julie and Ann, please take it away.
All right, thank you so much, Eric. It is nice to be with everyone today. We have obviously saved the best for last, changes to the Illinois Pay Equity Act. We knew everybody wanted to stick around with us to learn about crunching those numbers, everybody's favorite thing to do. But all jokes aside, Sarah and Jen had presented on a lot of changes to Illinois law, but this is a big one, so we decided to kind of break this out on its own. There are going to be a lot of new reporting obligations under the changes to the Illinois Pay Equity Act, so we wanted to give you an expanded understanding of the changes and the obligations that employers in Illinois now have. So now that we've got a little background here, and I've gotten pretty much every joke we could say about the Illinois Pay Equity Act out, I'll turn it over to Julie. And Julie, why don't you tell me, what is the Illinois Pay Equity Act and what does it cover?
Great, thank you, Ann. So the Illinois Pay Act is a law from 2003. The purpose is that it prohibits employers from paying unequal wages to men and women for doing the same or substantially similar work. It also prohibits from paying African-American employees less than non-African-American employees for, again, doing the same or substantially similar work. So then how does this work? What's the procedure? A brief overview there is that the employee would file the complaint with the Department of Labor. This is the Illinois Department of Labor. Thereafter, the Department of Labor would conduct an investigation. Now, what's important to keep in mind is that an employee doesn't need an employer to file this complaint. The Department of Labor will thereafter issue a finding saying that there is reasonable cause or reasonable cause does not exist in the claim. And also, please keep in mind the statute of limitations is 3 years for a claim under the Equal Pay Act.
Thanks for that explanation, Julie. That was very helpful on what the Illinois Equal Pay Act is. So really to the meat of the presentation, what are the changes here and what are the new requirements that we have under Illinois law for the Equal Pay Act?
So the biggest change is that now employers will have to obtain an equal pay registration certificate. You might see the acronym EPRC everywhere, so keep that acronym in mind. This is what it stands for. We'll otherwise refer to it as the certificate. So first off, this is only applicable to private employers with 100 or more employees.
So I think, Julie, that begs the question, how do you determine whether you have 100 employees? And I think the big question here, post-pandemic is, does that include remote employees as well?
So that's a great question, Ann. So to start, it is 100 or more employees in the state of Illinois. So if you're a company and you have multiple offices across the United States, only count your Illinois employees. Now, you asked a great question about remote employees. Say someone works out of an Illinois-based office but then lives in Oklahoma. It is based off of where the employee's office is. So if they work out of that Illinois office, it counts. If they do not work out of that Illinois office, it does not count. So then the purpose of the certificate would then be to show that the average compensation for the company's female and female and minority employees is that the purpose is that it is not below the average compensation of its non-female or non-minority employees. So then we're going to get into the registration timeline. So first, we're going to start with, what if you're authorized to do business as of March 23rd, 2021? Okay, so we have an application time period here. It's March 24th, 2022 and March 23rd, 2024. So you notice that this is a big time frame. Something to keep in mind is that the Department of Labor has already issued notices to certain employers. So there's really no rhyme or reason, would you say, Ann, to who's gotten these notices yet?
That is correct. So even though the actual changes to the law say you have this 2-year period to get together all your information, submit it to the Illinois Department of Labor, we have seen that the Illinois Department of Labor has actually been proactively reaching out to certain employers and saying, you need to work through the registration process now, and you have a certain amount of days to complete it. It's usually a decent amount of time, several months, but they have been giving those notices, and there really is no rhyme or reason who is getting those notices, so you should be on the lookout. But otherwise, do know that regardless, if you have 100 employees or more in Illinois, you're going to have to report during this registration timeline.
So then also keep in mind, what if you started a business in 2021? Well, this is when you have to keep that March 23rd, 2021 deadline in mind, because you don't have to file within that 2-year time period. You actually have 3 years, and it's within starting your business operations, and it's not before January 1st, 2024. So I guess that 3 years is kind of cut off by the fact that it's November 1st, 2022. And then another important thing to keep in mind is that you do need to apply for recertification every 2 years thereafter.
And so we thought it would be helpful to show you all the certificate issuance process. It is very detailed. This was provided by the Illinois Department of Labor. You can find it on their website.
Yes.
But this is what the process looks like when you apply for your registration certificate. Julie, do you want to give us a little bit of an outline of what that process looks like?
On this really easy timeline, yes, I would love to give you an outline on this really easy timeline and flow chart. So first, I do want to say the Department of Labor created this flow chart. We did not. Please submit your complaints to the Director of Labor, not to Husch Blackwell. So where you're actually going to want to look at, it's contained in closer to the upper right corner. It's EPRC issuance. That's where you want to end up. Why it's somehow in the middle, again, we didn't make this, but you'll see the process here is enrollment, and then we're going to get into what it takes to go through the application, and then in your perfect world, you get this certification. Well, I think the Department of Labor might be anticipating not getting it on the first try and what to do thereafter. And then this lovely flow chart does also explain the process for recertification as well.
Excellent. So as Julie alluded to, you have certain application requirements. And so when you're going through the registration process, there are essentially 4 things that you need to do to register. You have to provide to the Illinois Department of Labor a copy of your most recent EEO-1 report that you filed with the EEOC. You have to provide a list of all employees during the past calendar year, separated by gender, race, ethnicity, providing their wages, their hire date, their termination date, and also their EEO-1 job category. In addition to that, you have to submit an equal pay compliance statement and, of course, a $150 filing fee.
Okay, Ann, I have some questions for you. How do you determine wages? Are we looking at salary, W-2?
Yeah, absolutely. That's a really great question, and one that we've gotten a lot. The Illinois Department of Labor states that what they are really looking for is the W-2 Box 5 wages.
So what's that, Ann?
That's on the employee's W-2 in the Box 5 for their total wages that they have received throughout the year. I think the other thing, too, that Julie, that we should really point out here, too, and a question that I've been getting a lot from employers is, what happens if someone's promoted during the middle of the year? So technically, you're going to have 2 lines for that employee or more. Maybe they're a really great employee and you've promoted them 3 or 4 times. You will have at least 2 lines, and you will have the hire date and the promotion date and the salary that they had during that position. And then when they are promoted into the new position, you will have a completely separate line with the date that they start that position. And if they're still employed, obviously you just say still employed. So we've been running into that question a lot as well.
So what do these look like?
Yeah, absolutely. And you'll see in a little bit here, the Department of Labor does provide a lot of resources for you. So here are some examples of what the certificate template looks like. So what the Department of Labor is looking for you to submit to them. It's basically an Excel spreadsheet with all this information filled out. And as well, the compliance statement. And the compliance statement is going to be filled out by someone at the employer who has knowledge of the audit that has been done. They're going to state that you're complying with the applicable laws, paying employees that are in the same position fairly and equally. It's going to state that you're not restricting employees of one sex to certain job classifications, that you correct wage disparities when they're identified. They're going to ask how often you evaluate wages. And I think the one thing that we probably would get the most questions on as well is the very last one, is the type of approach taken by employers when they're evaluating these pay equity, doing these pay equity audits. So, whether you had a market price approach, whether when you determine pay, you're using prevailing wage, or whether you've done an internal audit. So these are the selections, and you would indicate with the Department of Labor what approach you used.
And so as you'll see here, we do have the important resources for you. If you look on the screen, so I think there is a resource box where you can go and you'll actually be able to find these links. The big one, if there's one link that you're going to look at, go to the Equal Pay Registration Certificate homepage. That is going to take you to all of these other links. But to make your life easier, the first thing you are going to have to do is create an Illinois Public ID account. So we provided the link for that. And then the Department of Labor actually makes it fairly easy, and you just have to upload all of this information to their portal. We provided the portal, and you'll be uploading the compliance statement, which we just talked about, and that certificate template, which was that Excel sheet that you saw on the last screen.
Yep, absolutely. And so, Julie, you alluded to it a little bit before. So we've gone through, we've submitted all our information. And so what happens then once all the information is submitted to the Illinois Department of Labor?
Well, in a perfect world, you get the certificate, but that's not always the case. So as you can see on the screen, within 45 days of receipt of the application, you'll either be issued the certificate or a statement why it was rejected. And then the Department of Labor does give you 30 days to cure any deficiencies. So something else that's important to keep in mind is that this may be revoked or suspended when the business fails to make a good faith effort to be compliant with the Act.
And so, Julie, I think this is an important question for employers so that they know, are there any penalties for noncompliance?
There are, up to $10,000. So falsification and or misrepresentation on an application will constitute a violation of the EPA. The department will seek to revoke the certificate and will impose civil penalties, which you'll see of that $10,000. That is for noncompliance. And if you have any falsification or misrepresentation, that's also an automatic $10,000 penalty.
Right. And so I think what we really want to point out to employers here today is, why are we going through this? Why is this important? Why does this matter for employers? That when you're submitting this information, the new changes to the law actually allows the Illinois Department of Labor to review and identify the pay disparities, and then they can take that wage data that you submit and turn it over to the Illinois Department of Human Rights and the Office of the Illinois Attorney General, which both enforce those employment discrimination laws, so they can effectively use that information to bring a lawsuit against the company for violating equal pay laws. It also allows the Illinois Department of Labor to compile aggregate reports based on this wage data submitted and that are not required to be kept confidential. So that information can be released to the public. So I think it's really important at this point for employers to really understand that this is a requirement, and it's really important that you are doing these pay equity audits in order to ensure that you're not exposing the company to more liability, because the state is going to be looking at this information and they're going to be looking at it closely. So really, employers should be using this mandate as an opportunity to reassess pay practices, do those pay equity audits, and maybe not even necessarily just in Illinois. I do think this is potentially something that's going to be adopted in other states. Illinois tends to mirror California, New York. I wouldn't be surprised if we're seeing some of this in other states as well.
That's very helpful to know. And I think the big question that everyone's wondering is, what do you do as your role in the attorney? How do you help compile this information?
Yeah, absolutely. I think it's really important that going through this process is to engage an attorney to help you with this, to do the equity audit under attorney-client privilege. We highly recommend doing this pay equity audit under attorney-client privilege because we'll assess the data, we'll look through it, we'll determine whether there are any pay disparities, what should be fixed. We can do this all before you submit to the Illinois Department of Labor. And then this is all done under attorney-client privilege, can't be released later if you were to, say, get a lawsuit. So we highly recommend that you do this with an attorney to help keep this information privileged.
And I think one of the big questions that everyone may be wondering right now is, so you're saying what, I can never have any pay discrepancies within my employees? Well, you do have defenses. We've listed a couple on here. These mostly mirror the federal law, but with that said, when you see these come through, these are the defenses we want you to keep in mind. Think a seniority system, merit system. These are pretty self-explanatory. A system that might measure the quantity or quality of the production or the goods or services. And then another one that we see where this is often referred to as the catch-all category is a differential based on any other factor other than gender. You might read it as factors other than sex. And so what's important to think here is think market forces. In a defense, sometimes you can have an outside company conduct what they call a market report, and they can have explanations as to why there could be pay disparities or pay discrepancies.
That's a really great point, Julie. And so I think one of the other things, too, in looking at going through this process and looking at the internal processes that you have as an employer is how you can help mitigate this liability potentially going forward. So, Julie, can you tell us a little bit about that?
Yes, and we do have an example on the screen, which we'll get to, but as you can see at the top, we say narrowly tailor those job descriptions. The most important classifications are going to be to measure employees based on the content and responsibility of their jobs. So think content and think responsibility. In general, there are 3 criteria that employers should keep in mind when doing this. Think about the responsibilities and the primary duties that the employee will be doing at work. Think about the knowledge and the skill of the training. That's another important factor. Not everyone is going to have the same requisite background. And another to keep in mind is the level of skill required. So when you draft these, sometimes our advice is keep everything in alignment with the EEOC guidance. There are different types of levels of categories of employees. Now, one of the biggest ones that we have on here is a distinguishment between executive and senior levels. We'll call them officials, managers, or sometimes you have individuals who might be more of that, they call it first or mid-level officials or managers. They just see the title director, they see the title manager, but it's important to know that there are differences in their job. This is going to be key. This is one of the most contested categories that we've seen because we see someone with the title director who maybe falls in this bucket on the right that's more of a first or mid-level where you can see the duties or the position names outlined there, but they're claiming that they're actually someone that they should be compared to someone in this other bucket, which is more of an executive or senior level manager.
Yep, absolutely. That's a great point, Julie. And I will say, working through working through this process with several employers, we've used this as an opportunity to reassess those EEO1 categories and match them up to the job descriptions, make any changes that need to be made. It's a good reminder to go through this process and make sure that everybody's fitting in the correct category so that they fit and the salaries make sense. There may not be any, disparities in the pay.
And there are different categories to keep in mind, too. We have professionals, technicians, sales workers, laborers. We showed you what was most contested, but do keep in mind there are different levels and structures and categories of employees.
Yep, absolutely. And so to really round this all out, we have a few best practices as employers kind of gear up to go through this process, not only in Illinois, but just in general. Really, we highly recommend that all employers should be conducting these equal pay audits internally and repeating them once a year, or at least every couple of years, to make sure you're on track, that things are consistent.
We got into drafting strong job descriptions. If you can categorically show the difference between 2 employees, that's going to be key in showing why there could be a discrepancy in their pay. Most importantly, you just want to always be able to practically justify pay disparities. You don't want to be stuck in one of those scenarios. You want to be able to point to a sheet of paper, to data, or any analysis as to why there is a difference in the pay.
Yep, absolutely. And I think this is also a good chance for employers to look at their salary setting processes for new hires and promotions, making sure that you've got a uniform process, that it's not just at the kind of discretion of the individual manager for that department, that you have kind of a uniform process that maybe cycles through HR, so that you're ensuring that this is looked at every time you have a new hire, every time you have a promotion, so that, when it comes down the road and in 2 years when you've got to recertify, you're all set. You know you're good because you put these processes in place. And I think most of all, just call your favorite Husch Blackwell attorney to help you issue spot.
We would be happy to do so, and keep in mind, as Anne's already discussed, it would be privileged, which is just so important and could be key in moving forward in something like this.
Yep. So that's all we have today on the exciting topic of pay equity. I know you all stuck with us through the end because you just could not get enough, but I will turn it back over to Eric to close us out.
Thanks so much, Anne. Thanks, Julie. Thanks to all our presenters for doing a terrific job today. Thank you, audience, who joined us today. I hope you learned a little bit. I hope we had a chance to answer many of your questions. To the extent that you still have questions on the topics we touched on today or anything else, please feel free to reach out to us. All of our contact information is available in that portal. As a reminder, the program has been approved for HR and legal education continuing hours. You can report those hours through the CEU icon on the bottom of the screen. You're going to receive a certificate of attendance that is going to be emailed to you tomorrow, along with the recording that you can share with others in your organization. Finally, we'd love you to complete that survey. It really helps us refine and enhance our offerings to you. We have 2 more labor and employment presentations left in our national series. We've got the Kansas and Missouri seminar scheduled for November 15th, and the California, our final presentation, scheduled for the 29th. I hope to see some of you then. Thanks for your time. Go enjoy a Chicago-style hot dog.